Yeah. Hello, everyone. Welcome to Uncivil Law. I hope you're having a wonderful good morning. And with me, as always, is the not late and also great Nate the lawyer. Yay!
Hey, what's going on?
Yeah,
Trying to make it happen, baby.
And we are here to talk a little bit more about the Toddy, Westbrook, Katie, Joy Paulson drama, which is really, of course, the Michaels drama. This is the story of the Michaels, like Remus and Romas or something. Twin brothers, Reman and Romas or something. Yeah, twin brothers fighting for power or something over ancient Rome.
Well, the first thing I want to say about this whole madness is that what the hell happened to the motion to dismiss?
I don't know. It's forgotten about. I don't know. It's lost. It's lost to time. Maybe some aliens will come visit our Earth, and they'll be able to find it someday in their archaeological studies, because that's how long gone and lost it is to us. So maybe some superior race will be able to find it someday.
Maybe it's this happened to be a motion to dismiss with snitches and backflips and all. What the hell? Oh my god! So you want to fill the people in on what's going on?
Sure.
Or should I?
Why don't you fill people in with what's going on? Because where do I start on this?
Okay. Yeah. So everyone understands. So I got to give people a little bit more context. Let's start. So I don't want to start at the beginning, but I'm going to start. Brown, because I'm doing the same thing you were doing. Brown, KJ's attorney, before filed a motion for sanctions against Toddy's attorney, who's the plaintiff's attorney, Saltsy. We call him Saltsy because Emily calls him Saltsy, and I like the name, Saltsy. So Brown filed a motion to sanctions against Saltsy. Now, the motion was about a couple of things. Number one, it was about the Lorianne declaration, right? Lorianne is the person who flipped. She was on team Katie. Now she's on team Tati. So that's what the motion for sanctions were about. Now, this was after they had just come together and said kumbaya. Then Brown hits him with this. So this kumbaya was over, and Brown hits him with the motion for sanctions. Now, in that motion for sanctions, so we can all be clear, in that motion for sanctions, Brown is making a couple of arguments. And the argument that we're focusing in on, I don't know if you want to read that super chat.
I was just putting on stream to acknowledge
it. First super chat of the day. So just so we're all on the same page, one of the arguments that Brown made in that motion for sanctions is that Lorianne was represented in some quasi way by Brown, and that Saltsy should have recognized that and not got the affidavit from Lorianne because she was represented, and the fact that Saltsy should have known that the affidavit that Lorianne was making was false, right? Because she was saying things. So two things: that he was more or less supporting perjury to the court, and second, that he shouldn't have even done it because she was, a reasonable person would have known that she was represented by counsel. But in the background, which we just found out, because Brown then makes this next filing, and in this next filing, Brown then shows emails, right, in correspondence between Saltsy's crew and Brown's crew, where Brown is behind the scenes actually asking Saltsy and his crew to come to an agreement, to a stipulation that Brown was never represented Lorianne. So that's what Brown is asking them in the background. We want to stipulate that I never represented Lorianne, so just in case she becomes a witness, I can just crush her. So Saltsy's team was like, no, we're not going to do that. What are you talking about? We want to see first to get some more information, essentially. We want more information to see if that's actually true. So Brown then makes this filing saying that he wants the court now to acknowledge that he never represented Lorianne, so he can stay on the case. And if Lorianne becomes a witness, he doesn't have a conflict and he can go after Lorianne. But that's in direct conflict with the motion for sanctions, because if that's true, if he never represented Lorianne, then this motion for sanctions is garbage, but it was based on a reasonable person believing that he represented Lorianne, which he is now saying definitively that he did not.
It's more nuanced than that, or at least it's trying to be more nuanced than this. And I really think at this point, just thinking of it as a soap opera is actually pretty helpful at this point, because you have one of the things that makes soap operas, I guess, interesting is trying to remember what every character knows from their own frame of reference, because and you have all these intrigues with different relationships and who knows what and when do they know it, right? So
yeah,
this is the soap opera appeal. It's these really complex stories because you have multiple different characters with multiple different frames of reference. Different characters know different things or betraying different people and whatever, so you have to like remember what you're talking about at any given time. So thinking of this as a soap opera is actually a pretty good plot. So we've got as major characters so far in our soap opera as time turns, or what should we call the soap opera? We need a good soap opera name.
I don't know. I'm about to say I can't say The Young and the Restless. The you know, I don't know. It's not. But I'm trying to think about a good soap opera name.
As the Wheel Turns. Yeah, As the Wheel Turns. Let's go with that. So in our episode of As the Wheel Turns, we've got Toddy Westbrook, James Westbrook, and the company, the beauty gurus, just trying to get by with making their beauty products. We got Katie Joy Paulson, and without a crystal ball, the skeptic who loves to criticize the poor makeup people. We've got Brown, the attorney, representing Katie Joy, aggressive, dominating, and biting. And then we got Salts, the plain-spoken one, representing Toddy, just kind of sitting there and kind of being like, what is this net mess? And then a wild Lorianne appears as the fifth wheel in our matrix, the witness who flips sides. And so this whole thing has become a drama that you have to appreciate the drama of it. Okay, so yeah. So Brown is trying to have his cake and eat it too. He's trying to argue different things from different frames of reference, it seems to me. He's trying to argue this really nuanced point. So he's saying, here's what he's saying at this point. I didn't, in fact, represent Katie Joy Paulson.
No, Lorianne.
Lorianne.
Yeah.
See, I script the names. You got, yeah. I didn't represent Lorianne Barnhart. Lorianne Barnhart, or any reasonable person in her position, would not believe that she was represented by me. So Lorianne shouldn't have believed it. Nevertheless, when Lorianne went to Salts, when Lorianne talked to Salts, Salts should have drawn the conclusion that she was represented, even though that was not in fact true, because of what Lorianne was saying. Based on what Lorianne believed, Salts should have drawn the conclusion that Lorianne was represented by me, even though that's not in fact true.
Even if it's false. Even though it's false. He's saying
he should have drawn the false conclusion.
Yes.
Yeah, he should have drawn the false conclusion. Having drawn that false conclusion, he should not have proceeded to file this because he believed she was represented by me, even though that's not true. Correct. So yeah, you gotta like fully appreciate the multiple frames of reference and what's true from what's point of view, because this is how he's trying to slice this that some other people are not appreciating. He's trying to argue he's trying to argue his own frame of reference, Lorianne's frame of reference, and Saltz's frame of reference all at the same time.
Yes, exactly. But the problem is that this doesn't make any sense. Why would he's making two arguments here that essentially he's arguing against himself again in this situation. Like, you know, even though you like, for me, I'm not understanding if he's asking for sanctions for more or less his client being talked to by another attorney.
Yeah. And
he admits that wasn't true. She wasn't his attorney. He's asked the other side and asking the judge, she wasn't my client. Everybody should know it. Please stipulate to it. Then you have no beef.
I do like this. Because I don't think he can do this, but it's an interesting thing because it's one of those ideas of like, you think that you're breaking the law, but you're not in fact breaking the law, so you didn't break the law, but you believed you did in your own mind. We saw this. We covered a case sort of like this recently on my own channel, where a guy was trying to lie to the FBI. His intent was to lie to the FBI, but he actually told them the truth. So he's trying to lie, and he failed. He failed in his attempt to commit a crime. So, you know, there you go. So what he's trying to argue is that the reality of the situation shouldn't matter as much as what Salt's subjective knowledge / intent is or should have been given this information. So now we're spinning into hypotheticals from a third party frame of reference. So it's like, hopefully everyone can keep this straight in their mind, because this is a complex character study. But he's trying to say that Saltz should be sanctioned because Saltz did believe, or should have believed, that Lorianne was represented, and therefore he thought he had the mens rea. He had the mens rea to commit an ethics violation, and therefore he should be found in responsibility for the ethics violation.
Yes.
And the obvious counter would be, but actus reus, though. Because I might have had the mens rea, but I didn't have the actus reus because you weren't in fact represented, so I couldn't break the ethics rule.
Well, that's the first thing I would say. I was like, well,
Yeah.
you didn't represent her, right? You actually didn't. And I came to that conclusion based on what she's saying, based on evidence before me. I said, obviously she's not representing her. And then you came afterwards and said, it was obvious I wasn't representing her. I came to the same conclusion, that I came to the right conclusion based on the evidence. And you are saying, yes, you should have come to the same conclusion, but you haven't.
Yeah.
Look at the thing that I shared. So this is from the sanctions motion.
Yeah.
Right. So check this out.
Yeah.
So when you look at this is
you got to read this very precisely when we're talking about the mobile frames of reference, because you got to read it very precisely what's being said.
It says Ms. Barnhart contacted plaintiff's counsel, who proceeded to interview her for 11 hours and review her emails with the undersigned, despite her telling them she was represented by the undersigned. So he's saying that she told them that she was represented by the undersigned, and they still went through this.
Right.
But that's not. But then, and so here's what he's trying to say: that Ms. Barnhart called plaintiffs, blah, blah, blah. She explained that she believed. Now, this is where they get to. She believed
she was represented. Yeah. So this is going to Lorianne's belief, and therefore Saltz's belief. So they both believed a lie.
Yes. So now the next one: plaintiff's counsel proceeds to procure Ms. Barnhart's signature to sign declaration, which contradicts every material aspect of the story told to the undersigned in the first. So now it's kind of like, well, hold on. If she believes she's represented, but she wasn't. Yep. So it's kind of like me saying, well, I believe this is my attorney, and then the attorney says, well, why do you believe that? Oh, because of X, Y, and Z. And I say, well, no, you're not represented because X, Y, and Z. That's not how you represent. Did you sign anything? Did you do it? Or are you officially represented? And the person says no. Then you say, okay, well, you're not represented by him because here are the ways you're represented by an attorney, and you're not. So your belief seems to be unreasonable. So I'll do this. So we haven't heard the other side, but that's essentially what I think Salty is going to say. Well, I asked her, did you guys sign a retainer? Did he offer? Are there any emails where he definitively says, "I am your attorney"? Right. And there would be a conflict here if you have a witness, if you're representing the witness. And
I think Saltz can get past this. No big deal. I think Saltz should be able to get past this, but like it makes kind of sense from Brown's point of view, but Brown hasn't really fully considered Saltz's point of view or what he did or didn't know, because what Saltz, Brown always seems to assume the worst. He always seems to assume the worst. So, and I was making a point of this last night. He seems to assume that Saltz had all the emails and all the correspondence, which is not clear at all. He seems to assume that Lorianne came flat out and said, I was represented. He seems to assume that Saltz decided to plow on without doing his due diligence and so forth. So Brown is a bit of a catastrophizer in his legal writings. Everything he says is kind of plausible, but it seems to be the most aggressive version of reality. So like this story makes sense, but it kind of doesn't make it probably isn't true if any of that distinction holds water.
There are a couple of problems with Brown's reasoning here from my perspective. Yeah. Number one, you're representing both the witness and you're representing the defendant, right? So now when this witness flips,
maybe.
But this is the issue that Brown is getting right now, right? This is the issue Brown. So everybody understands. We should just take this down. Sure. The issue that Brown is facing now, so everybody understands why this is a problem. Brown, if Brown represents without a crystal ball, and now it becomes adverse with Lorianne, and Brown has talked to Lorianne in this relationship, attorney-client relationship. Then if the other side calls Lorianne as a witness, right, to say, hey, this is what happened in Washington, Brown would not be able to cross-examine her. Brown would not be able to challenge her because Brown has a conflict between, she's told me things as a client, she's told me things as a client, so there's a conflict of interest, and Brown may not be able to go forward with the case because If Lorianne's up there saying that me and Katie had a deal and we were in Washington, that's why you should get jurisdiction, Brown can't challenge that because Brown represented Lorianne, right? You can't scumbag your client that way. You can't throw your client under the bus. So Brown is saying, well, she was never my client, so he can stay on in the case and get paid his $4.50 an hour. That's the problem. That's what Brown's problem is. So he now has two. So the two issues that he has is that, and I think Saltsy saw it, right? So I think Saltsy saw it immediately. I think Saltsy's not stupid. He saw it immediately. He said, okay, you're representing her. She's now flipped. Now, if I put her on the stand, you're stuck, right? And maybe you can't even stay on the case. So Brown now wants his cake and eat it too. He wants to say, well, I never represented this woman. So if she goes on the stand, I can destroy her, right? Yeah. But also, because you flipped her as a witness and I have to destroy her, you should be punished. So Brown is trying to have both sides of the same coin, but he can't because the court's not going to say, well, on one end, you can't argue that she was represented by the guy. She represented you. Everybody should have realized that you were representing her, and then on the back end said that you never represented her. Those, that dog won't hunt.
I don't think that. First of all, I don't really think that any of this really arises to an ethics violation, and bringing up this early in a case is really weird. To immediately go to ethics violations and sanctions as early is like, why? This seems odd. But putting that aside, I don't think the judge is going to go with the theory of Saltz subjectively knew or should have known, or believed or should have believed that Lorianne was represented. Therefore, the subjective belief is enough in and of itself. The objective reality, according to Brown, is that she wasn't represented. So I don't think the subjective belief will get you there. There has to be an objective reality, the way I read the ethics rules. So it's like it's a mens rea and actus reus. So he had one without the other. He had the mental state, maybe, but not the act, because he can't. It's like breaking into a car, but it's your car. Well, so it's like,
I disagree. No, when it comes to the ethics violations, I think there's an aspirational piece of it, which you ought not to do.
There's definitely that.
In the sense of, you ought not try to support perjury. So even if the person doesn't perjure themselves, the fact that you went through the process of avoiding it, that is the violation of itself. I think here the failing is that Brown can't, on one instance, argue no reasonable person would have thought that I was representing her based on even what she knew, right? And then go to because he went to Saltsy, he went to all these people and said, hey, no reasonable person would have thought that. I need you to stipulate to it. But then on the back end, say, well, Saltsy, who he's holding as a reasonable person, should have believed that she was representing him. That's essentially he's trying to play both sides of the equation, but it just doesn't add up. You know what I mean? That's where I think this fails. And you're right. I think at a point, the court's going to say, well, what was true? Were you representing her? Were you representing Lorianne? And as soon as she says no, then we don't have a problem. If the answer is
no, then I think we're done. Yeah,
we don't have a problem.
Yeah, I think we're done.
Yeah. But I think if I was Saltsy, I would flip it on Brown, though.
He might. Yeah, Saltz can make basically the same argument in reverse.
I would flip it on Brown.
Yeah, you could do the same argument in reverse. You knew or should have known that you're represented. And when you're saying things like, I will file this and I will stand for you, it's like, well, that looks pretty suspiciously like you're representing them. And it was weird when I was reading the latest motion on I'd like to stay on the case, please, that every time Brown was speaking, I became more and more convinced that Lorianne was in fact his client. So he's trying to argue the opposite. I'm like, why is it every word you're saying? I'm becoming more and more convinced of the opposite. So yeah, this isn't working for me.
He's trying to have it both ways. He's trying to get obviously we need Lorianne. But the thing is that I want to make it very clear because I don't want people to think I'm a bad lawyer. I don't know what I'm talking about. I need people, please put me on put us on that smaller screen so I can look at the people, explain this 100% fully. Understand this, people. This is a motion to dismiss. So we all are clear where we're at and why all this stuff is insanely crazy and makes absolutely no sense. I need to make sure we explain this clearly. Katie Joy Polson has not responded to the lawsuit. She has not answered. Right. So all the allegations as of right now are ostensibly true, right? Everything that Toddy Westbrook is saying legally, we're understanding to be true. And on top of that, anytime there's a dispute as to a fact, that dispute is resolved in favor of Tati. The reason why is because Katie Joy Paulson has not officially said, I didn't do any of this stuff. Her position right now at the stage of a motion to dismiss is that
it doesn't matter if I did that stuff. It doesn't matter
even if I did it all.
Yeah, it doesn't matter.
You don't have a case. So this arguing about whether Lorianne was in Washington or this, even now, think about this. We have all these precipes and everything, right? So Katie Joy Paulson, let's just play this out so everybody understands. Katie Joy Paulson is saying Lorianne wasn't my agent, right? Then Tati is saying Lorianne was your agent. Mm-hmm. We have a discrepancy. So based on the legal standard, the court's going to say, okay, so you guys disagree? Well, I'm going to take this favorable inference in favor of the non-moving party, which is Tati. So guess what? It's what Tati says. Now,
I'm not sure that that's true for one important reason. Mm-hmm. When we're talking about this, it's everything in the complaints.
Yes,
that's taken as true, and the attachments to the complaint that's taken as true.
Correct.
There was no Lorianne was not mentioned even obliquely in the complaint. There was no suggestion of agency at all in the complaint. The complaint was Katie Joy has subscribers in Washington, viewers in Washington, super chats from Washington. She's done research in Washington.
Yeah,
right? So
you're correct.
I've taken the position that Lorianne doesn't exist for the purpose of the motion to dismiss.
I would even go as far as to say you're correct. But I think Lorianne being part of it doesn't even change it, because like you're right. Even if we take out the agency thing, it doesn't change it because we're assuming all that stuff is true anyway, right? She has subscribership. We're assuming all that stuff in the complaint is true for the purposes of this motion to dismiss. Now, if Katie Joy wants to argue that all the stuff isn't true, you answer the complaint and say all that stuff is BS, and then we go fight it out. But we're not at that point yet. So that's why we as attorneys are shocked when we see the defendant has 4 precipes and declarations. It's unnecessary, and you only open yourself up to ridicule and impeachment, legal impeachment, as a witness, because you're putting out all these statements that some have some contradictions in it. So that's why we're just kind of like in surprise about where this case is going, because essentially all this stuff is irrelevant to the point. Go ahead. I'm sorry.
No, let me just answer a couple questions because my bot is finally working and extracting all the questions from the chat. So yay. Tria asked, question, could Brown be purposely setting himself up to take what money he can and dip out? I don't think so. No, I don't think that's what's going on here personally. Grace Case member says, can Babs find no jurisdiction in Washington of the grounds of I hate you all out of my court? Not overtly, but that could definitely be the subtext. Lizzie says we need a Halo Beauty ad, please. I don't know about that. JC Mills. So did Brown commit perjury? No, because first of all, he's not strictly speaking under oath, but it wouldn't. So it's not perjury, but it would be a violation of the ethics rules. But I don't think it's that either, because he's trying to argue a very nuanced position. So he can try to argue this thin slice, and it kind of all makes sense in your head. Itria said, wouldn't he have learned to know better before he took the bar exam? Probably, I would imagine. Deanna, can Katie sue Brown down the road for wasting money? Oh, sure, it's malpractice. If it is, so yeah, they can sue for wasting money.
And this is a big waste of money.
Can KJ still say I didn't do any of this? Oh yeah, sure. We're at the stage of it doesn't matter if I did it. So there's a very distinct legal difference between it doesn't matter if I did it and I didn't do it. So we're at the it doesn't matter if I did it stage. Everything can be true. It just doesn't matter. Sure, maybe I did all those things, but whatever. It doesn't matter. So yeah, she can absolutely come by later and say, oh yeah, and I didn't do it, which would be the answer, which we still haven't seen because we haven't gotten to step 2 of this case, amazingly enough. Tanya says, is it common for a lawyer to write my Katie on a document? No. That's I've never written that. No, that's a strange
that could be a typo.
phrasing.
That's a typo.
It's strange phrasing. NATO 200 says, try out the Halo makeup. How much do I have to pay? Well, someone has sent me some Halo Beauty products in the mail. I know that because I've gotten the notification from my post office box. I haven't been able to get to it because everything in Texas has been frozen for a week. But yeah, thank you. So someone sent me some stuff. Kilman said, so after jurisdiction is ruled on, KJ will then have the opportunity to file an actual response. Yeah, absolutely. The answer would be the next thing that would happen after the motion for jurisdiction. where she can say, I didn't do the stuff. And oh, by the way, here's a whole bunch of stuff you did that I'd like to sue you for. And then we can have the whole motion to dismiss all over again and blah, blah, blah. And we'll never even get to discovery, Nate. It's never going to happen. JEQ said Lori can have been represented and Lori may have dropped him as counsel before going to Salts. Probably. Jessica, so you think KJ was confident her motion dismissed because that would happen with the Jilly Juice lawsuit? I don't know enough about the Jilly Juice lawsuit to comment as to what that might be, but thank you for all the many questions, and I'm glad the bot is finally working.
Oh, what about the? I think you missed the $20 super chat.
I put it on screen at the time, and I didn't because it didn't get separated. But let me
read it. I'll read it.
Oh no, I got it.
Okay.
Brown still needs to chill before the judge. I'll just put on screen again. Brown needs to chill before the judge decides that he has obviously dropped his jurisdiction challenge, because he keeps answering her to rule in other matters and barely referenced in this answer. Yeah, no, I think that's very, very much possible. And if I were the judge, and I've said this before, the motion that I'm trying to rule on is the motion to dismiss. All I need to really consider to decide that issue is the motion. Well, all I need to consider is the complaint. The complaint and its immediate attachments.
Mm-hmm.
And as to facts go, that's about it. Those are all the facts that are in the complaint. The well-pled complaint, those are all the facts. I take everything that there's true. Great. Then I consider the motion to dismiss and its response and its reply, and Sir reply if I'm feeling generous that day, for the legal aspects of it. Those are the legal. Yeah. So between those 5 documents, I had enough to decide this issue long ago. Then I would just go do my law research, as a judge would do, look up and see what the law seems to require, and then go do that. But I would not consider, I would just ignore pretty much, I'd ignore every precipice. I ignore everything else beyond that, because nothing has to deal with the motion to dismiss, which is the issue I'm supposed to be deciding right now. None of this matters.
And let's just be very clear too. If there's any dispute as to whether a fact is, if one side is saying the fact is left and the other person is saying the fact is right, the non-moving party wins, right?
Right.
That's where we're at. That's where we're at. Now, it's funny because you'll see in the comment section, especially in some of my videos about this case, is people say, well, no, you guys are wrong. Why are you guys saying that everything Toddy's saying is correct? You guys don't know what you're talking. I'm like, well, no, you don't understand. We're not saying that. Katie Joy's attorney hasn't said that any of the allegations are false, right? He hasn't officially said that, because that's called the answer. And if you answer, then you're saying that the court has jurisdiction. She's saying the question now is whether this court even has authority to hear this case, right? That's the question. We're talking about facts of the case when the court is just asking the question, do I even have authority to hear this case? That's where we're at now. That's why this doesn't make any sense. That's why this doesn't make any sense. And okay, yeah, if everything Toddy's saying is true, you still can't hear this case. Okay. And I'm also going to say this too. I still don't understand how Brown, this is still not talking about the defamation. This whole case is about defamation. When was the last time we talked about defamation in any of the defamation defenses?
I think the last time we talked about defamation was because it wasn't even in the motion to dismiss. So we only talked about it obliquely in so much as it wasn't there and me beating my head against the wall very famously. So last time we really talked about defamation was when we read the complaint. So
we have 62 filings, and the only time defamation is mentioned is in the
was number 1. Yeah. So 61 of these we've not been talking about it. Yeah.
Yeah. I think I hope for Katie Joy's sake, the motion to dismiss is granted, because if it is, then it seems like they're going to be playing this again in Minnesota or wherever they're going to do to get jurisdiction again. And I don't think this is going to be over with the dismissal.
I don't know what the point was for any of this at this point. I don't really understand, unless there's some sort of case law advantage that I'm not seeing in the Ninth Circuit versus whatever circuit Minnesota is in. But unless there's some sort of case law advantage, I don't know, because the question of what state would hear it isn't necessarily the law that would apply. So we can have a whole separate argument over which state law applies.
Yeah.
So even if we're in Minnesota, we can go apply Washington law. So we can have a whole argument about what state's law applies. That's wholly separate from this. So, yeah.
Well, you know what? Quick question: Would this be, because we are in federal court under diversity jurisdiction, right? So So this is, so is the Washington courts, because I'm thinking this, and I always confused about this. This seems to be more of a venue problem, right? Even though obviously it's jurisdiction for the Washington court, because really, since they're all the federal court system, we're trying to taking it from whatever federal district court in Washington and moving it, because they would essentially, I would suspect, if I was Katie, if let's say they filed it in Minnesota, in the Minnesota state court, then I could remove it to a federal court based on diversity jurisdiction anyway, right? I have by right. Right, this is over 750,000, and even if they file a state court, I can just remove it to federal court anyway. So, so we're really just talking about changing venue in the sense of this is in one federal court, and they're saying we should move to another federal court. But I think the dismissal on jurisdiction here, I think is Katie's best argument, but I think she should have attacked the defamation. I think any sane person would have attacked the defamation, but again, I don't know what their litigation strategy is, though. They may
apparently not to attack the defamation was the litigation strategy on that one.
you got a $10 super chat that just came in.
Yeah, I put it on screen. I hope the morons arrested for Capitol riots aren't watching the case and getting ideas for delaying tactics. Yeah, I always try to put the super chats on screen at least when they come through, but obviously I don't want to interrupt the conversation. Interrupt the conversation flow. So yeah, but it's not out of disrespect. It's just I'm trying to maintain the conversation with my guest. But yeah, so nothing makes any sense, and this is so soap opera-esque that it's like you gotta really follow the levels of intrigue. Maybe that's one of the reasons that my channel is now 70% women. Can you believe that?
What? 70%?
Yeah. According to the analytics.
Wow.
Yeah.
That's great.
It's different, that's for sure. Maybe that's what's going on, because women are more likely to like soap operas or complex stories or something.
Now you got to make it. Now you got to take that and put it into real life. Like go to a bar, and 70%.
Yeah. And I say, well, I'm doing fine for myself as it is over here, so it's fine. Yeah. But yeah, this is complicated. You got to remember. All right, so Brown is arguing, I didn't represent her, Lorianne. In fact, Lorianne shouldn't have believed that I represented her. In fact, Saltz should have concluded I represented her. Saltz did it bad by filing this. And then there's also the other aspect of this, which is more notable, in my view, which is that Saltz, Saltz. I keep trying to make sure I'm talking from a reference. That Saltz should have known that what he was filing was materially false, because Saltz should have had or did have access to all the emails and all the stuff that Brown did. And that's not clear what Saltz had access to or not.
Well, Brown's argument is that all right, from my understanding, what Brown's argument is that I looked at all this evidence and I created a document, and that document was factual, right? Factually correct based on the information. Lorianne then took that same information, went to Saltzy, and Saltzy created a document that was in direct contradiction to my document. But there's only one interpretation of those facts, what I said. Right now, the two problems that I think they have, Brown has, is number one, his document wasn't signed, right? And Lorianne could say, I didn't sign it because it was fake. And the document that Saltzy produced was signed, right? Under penalty of perjury. I'm signing this because it's true. So he's essentially saying the document that she didn't sign because she didn't believe it was true is the real document, but the document that she signed under penalty of perjury to go to jail is the one that's false. That it's a BS. I think the argument is BS, but we'll see how the judge, how the judge distinguishes it.
No, I like this comment because I guess it shows how different things can be perceived by different people and how different people interpret things. So I like the comment for this reason. So someone criticizing me, how terrible was that comment? So they criticized me for two things: that women are most likely to like soap operas, which, as far as I understand, is correct. The majority of soap opera people are women. So it would be correct factually to say women are most likely to like soap operas as opposed to men being most likely to like soap operas. Women are most likely because women are the dominant audience for soap operas. I believe that's just objectively true. So that
it's just like men are the dominant audience for football games.
Yeah, right? Men are dominant. So men are most likely to like football games because that's dominantly true, right? And then this other aspect of it where it was misinterpreted or misunderstood or how different people perceive things. And 70% followers are different. Well, it is different because if you look at standard demographics on YouTube, the standard demographics skew majority male. That's the standard demographics. They skew majority male. And so for me to have 70% female is different. And so someone says, well, how are you feeling about it? I'm like, well, it's different. It is different. It's different to the norm. So it's, yeah. So both those statements are just objectively true. And they interpreted them, I suppose, as sexist, which just goes to show how different people interpret different things, I guess.
Yeah, that's it's you got to be careful about every single word you say because somebody may get offended.
I don't want to be careful about every word I say because that's just annoying.
But we know what you meant. Let's just, because now we got to clear it up so we don't get the cancel. Let's just make it very clear. You enjoy having this many people watch, no matter what the gender is. If they want to learn law, it doesn't matter your gender. It just is outside of the norm that his channel, particularly that seems to be neutral, has generated 70% of women viewership when you would think that it would maybe 50-50 or may even skew toward men. My channel, for instance, is heavily biased toward men. So I have, I think I have like 60% of my channel audience is male versus yours being 70% women. So you know what I mean? So like let's stop with the try to cancel them. I agree with the assessment. There are certain types of materials that women like more than men, and there's certain types of material that men like more than women. It's just the nature of the beast.
Yeah, and then we have this comment from Serendipity, who I guess we'll presume for the purposes of this comment is female, who says, I like football and don't enjoy soap operas. Right. I didn't say all women like soap operas. I didn't say no women like football. Right. So this is just listening to what I said. I said most, exactly I said, but yeah, most viewers of soap opera or women are most likely to like soap operas. Right, because they're the dominant audience. Does that say that every woman likes soap operas? No. It's just if you're going to take a guess, if you're just going to pull a random person out of a soap opera watching crowd, it's more likely to be women because more women watch soap operas. If you pull a random person out of a football crowd, it's more likely to be men because more men watch football. Is that saying that women can't watch football or men can't watch soap operas or can't like those things? No. It's just a statement about, and to say that most channels skew male, which is true, obviously doesn't imply all channels skew male because this channel doesn't skew male at the moment, which makes it different to the standard on YouTube. It is different from the standard. So I don't know what's going on here.
Yeah, you have a $20 super chat.
Yeah, where I'm trying to. Yeah, Paulo Greyo says, "Isn't it ironic he was calling out not for having a DID? What's DID? And he acts like
he was not for DID. Calling out for having
some sort of mental disorder,
like he has." I don't know.
Deficit disorder? I'll say it's deficit disorder because I think that might be a pipe rather than an I. So I'll say it's deficit disorder. Acts like he has deficit disorder. If he wants to leave because he chose the flawed defense, he should leave. Also, I love soap operas, but this time it's just baraha. Okay. Noted. Okay. Yeah.
Yeah, I think if anybody, it's like, for instance, I love 90 Day Fiance, but that show isn't made for my demographic. You know what I'm saying? It just isn't. It's made for my wife and for all her friends. Like I can't talk to you about 90 Day Fiance because you probably
not really.
You know?
No.
Yeah, it's not because you're a male. It's just because the show's not. The View, for instance, I watch The View, but sometimes, I know that show is for women, you know what I'm saying? Where if I watch ESPN, I know most of those shows are made for me, so it all depends on the lens. This is not saying that men and women are equal. It's just saying that we have different tastes. And I think that's just objectively true. So it is what it is.
Yeah. I don't know why any statement concerning sex was necessarily sexist to just say, here is the skew. But, okay.
but let's get back to the thing at hand before we get out of here. Let's just so at the end of the day,
yep.
What does all this have to do with the essential with the bottom line issue? Let's just understand it to be clear. This back and forth is meaningless. It is ridiculous. It is unnecessary to the legal argument and the legal issue at hand. Does this court have authority to even hear this case based on personal jurisdiction? That's all we're talking about. And any dispute amongst the parties about the facts are weighed in favor of the plaintiff which is the non-moving party, which is the standard for a motion to dismiss. And if Katie does have a problem with any of those facts, she should answer the complaint and fight it out after discovery. That's not where we're at. Right now, we're at the point of everything Toddy's saying is true, but so what? Just like you said. So what do you think is going to happen? Do you think eventually the court's going to rule on them? Like now, I don't even know when is the court even going to rule on the motion? You have the time, you have the evidence, you have everything you need. Why not just rule on the motion to dismiss and get these people out?
I'm not sure 100% sure the court is paying attention to what's going on at this point, because the court in its last status conference said essentially, why don't we just go deal with the personal jurisdiction, deal with the rest later? So I wouldn't be surprised very much if the court is just kind of throwing it in the proverbial circle of files, like, well, all this is interesting and all, but I've stopped paying attention to any of this. That'd be kind of like what I just let them file and be like, yeah, I don't care anymore. I'm just gonna go do the personal jurisdiction thing that you guys asked me to do, like way back when. I remember. I and Pepperidge Farm remember. We remember the things. Yeah. So.
Yeah, but it's dissociative disorder, dissociative identity disorder, multiple personalities, and the soap opera gets lost in the stupid crap. Just hold the attention of the audience. That's true. That's true. That's a nice pick too. I can be able to see it, but it's a nice pick. You see, being educated, DID, dissociative identity
learn
disorder.
Something new. It's always a plus.
But let's also recognize that I think now we're spending a lot of money that's unnecessary. The motion to remember they just striked one of his motion to expedite a hearing. We're spending and I think even this now is getting to the realm of spending more of my client's money to now try to stay on the case. I think Brown has made his own bed now with this Lorianne thing, and I think Brown is now scared that he may not be able to continue because the court can say, well, I think you're conflicted. I think because in Brown's situation, I want to be clear. If Lorianne really believed that Brown was her attorney, then I think Brown would actually be conflicted out, because then you can make the argument that no matter even though he's saying he never represented her, right? The fact that she believed it, she could have told him things that would have put her in a position where now he has information that he would not have had if she didn't believe that he was her attorney. So the fact that he could have gotten that information may conflict him out. That's why he needs either the court or the other side to okay this, right? To okay the fact that he can go after her. But I don't think, if you're just talking about ethically, I think he does have an actual problem here. And I think the problem is that he really can't have it both ways. You can't be saying that she told you that I might be representing her. She's told me all these secret things, but now I want to use them against her, because I wasn't really representing her. I don't know how this is going to go. What do you think about the actual ethical issue against Brown? Because I think Brown has the more ethical concern than Saltsy.
Well, I don't think he did anything wrong at the time that he was talking to Lorianne.
Of course,
at the time he was talking to Lorianne, there was no conflict between Lorianne and Katie.
Yeah.
So there was no problem at that point. And if at some point it became a problem, he couldn't represent both. So then, that would be fine. So I don't think there's any ethics violations at this point.
No, but don't forget, but now since if Lorianne becomes a witness in this particular case, right? Because obviously it's probably going to come down to, let's say jurisdiction is found. Then how can Brown go on if he knows Lorianne's going to be a witness? Because that's the first thing I would bring up. Saltsy, well, he can't continue because he's conflicted, right? The witness that's saying that his client is lying, he was quasi representing them both. He
might be conflicted for the purpose of that witness.
So what's Katie do? Just she says you can't cross-examine Lorianne?
Get a different lawyer to cross-examine and solve the ethics conflict that way.
I don't know. It's going to be interesting. That's going to be interesting.
Why not? It's just hire someone to do that cross-examine who's not affiliated with his firm. That solves the ethics problem, and everyone's happy-ish.
I don't know, man. I don't know.
I seriously doubt that Lorianne's going to be a witness in this case. I don't see there being witnesses in this case because I don't see it getting that far. I think this will be solved some point before trial, one way or another. So,
what do you think? You think there's going to be a handshake agreement?
I don't know, summary judgment maybe.
I think so. Well, if you're going for summary judgment, then they'd have to at least fight the defamation, because that's, and you're talking about
which
after
which they can do in the answer, and they must do in the answer.
Yeah, they got to deny the defamation, or they're screwed. But again, you deny the defamation, you go to discovery, you get all the facts, and then you go for your motion for summary judgment, because you're saying, well, even if all this is true, then but we're back at the same standard that we should be here, but that you should have been arguing already before. So I don't know. I don't think this survives. So you're honestly saying you think that this doesn't survive a motion for summary judgment?
From where we sit right now, I mean, obviously a lot can happen between now and then. A lot, not for the least of reasons that these depositions are going to go on forever. Can you imagine being Saltz and his team and deposing Katie Joy? Because you have to go over all those videos. How long will that take, Nate?
That's a lot of time. That's
going to take forever. So there's a lot that can happen in between now and then. So it's a little bit hard to project out with that much uncertainty. But I'm going to say I think that there's a decent probability that this could be solved by summary jurisdiction.
Oof. It's going to be difficult, because I honestly think Katie being a commentary channel and all this stuff, I think the case is, I think the defamation case is weak. But we'll see how it goes. Like you're saying, there's a lot more to come. But as of right now, I don't think it survived. I don't think it would have survived the motion to dismiss if it was pleaded correctly. But I think if you go on to motion for summary judgment, I think it's done. But go ahead. Do you want to read that super chat?
I was just saying, has anyone ever seen Brown and Katie in the same room? I think Katie pulled a Kaiser Soze. They do seem to have similar temperaments. I'm not sure if Brown is reflecting his client's temperament or what's about that. Radioactive Redhead says this feels very Perry Mason, but on a budget. Yeah.
Well, two things, and the things that we've theorized privately about is that, how is Katie paying for this? $450 an hour. This is you're over.
There's no way that she has enough money to pay for this.
We're talking about
she has enough money. She said that she was getting. Yeah, she says she was getting money from her kid, because her kid has some sort of fund to care for him, presumably some kind of trust fund. But it's hard to believe that she has. It's hard to believe that that's possible, because that would violate the trust fund probably. And it's hard to believe that there's a big enough one. So it's hard to believe that Katie Joy has enough money, because especially at the end of the day, this is all just going to be a jurisdiction question. So the best possible scenario right now is that the court rules there's not jurisdiction here. We refile in Minnesota and we get to have the fights all over again. And I'm not sure there's much advantage to being in Minnesota, or what the point is.
Well, think about this also too. It's just that now, since we know the hourly rate of the attorney, which usually is something that you don't put out there, like that's actually attorney-client privilege, right? Your bill, how much I'm paying for my attorney. Usually they keep that quiet, right? Because if I know that you're paying premium for your attorney, I can bill you up, right? I can start filing stuff and making you pay that extra money, knowing that you're paying $450 an hour. You know that now a one-page motion turns into a 6-page motion, and with video clips and everything to make you spend up that money. That's why generally you don't have to tell how you're paying or how much you're paying your attorney. But now, since we know he's getting $450 an hour, I could easily see 100 hours worth of work being put into this case already.
Yeah.
Right.
Yeah.
So, and that's at a minimum. So we're talking about $40,000. At a minimum, right? Because we're talking about videos, how many press it pays. Look at all the hours of work that he had to put in with Lorianne, right? Yeah, look at all that. Look at all the emails and stuff with Lori at 6 minutes. He's talking to Lorianne, talking to Saltz. I would suspect at least 100 hours minimum. What do you think?
Yeah, that sounds more than that. But yeah, I think that's a realistic minimum point. Yeah.
Yeah, so we're talking about $40,000 minimum, upwards to $100,000. We're talking about, and he's got money to keep going, right? Because he's not saying we got a money problem. So I don't know how they're doing this, but at a point, money runs out, right? At a point, money runs out. So,
Yep. Well, I'm going to let you go because I know you need to go, and I'm going to do some Q&A after you leave.
One last thing before I get out of here, I wanted to ask you one question, and that is and I'm not trying to throw Brown under the bus. I want to make it very clear. But for $450 an hour and for Brown's experience, I'm kind of surprised at the level of representation that he's giving to Katie. Not to say it's horrible, but it's just not what I would expect for an attorney getting paid $450 an hour from the Seattle market. What do you think about that?
It makes me think I'm criminally undercharging people is what it makes me think.
Well, listen, you take care of your Q&A. I got another live stream. Thanks for having me on. And I hope we explained this to people so they understand it, but
As much as we can.
what the hell? It's not like we're attorneys or anything like that.
All right. Have a good one, Nate.
Later, guys.
Later. All right. So I'm going to stay on with you guys and answer some Q&A. He had to run, so I want to make sure to give courtesy to my guest, but I can stay for a little longer. Yeah. A little flakiness here on my beard line. There we go. That's better. Okay, let's answer some questions. Question: how much money has Katie spent? Who God knows. Can she claim this money back from anywhere? Not really, no. Her best would be a malpractice suit, and that's far into the future. Looks like Brown has exposed information from the sealed documents. Is that a problem? Probably not. No. If he wants to expose it, it's probably okay, because it wasn't sealed by like the court's order. It was sealed by them asking, and yeah, I think it's probably okay. Has KJ played a good game throwing Lorianne into the mix to do a flip-flop, throw online games the attorneys never met with? That would be really interesting if this winds up being some master plot for KJ, but I don't know if we should give that much credit to it. Do I think the judge will rule on jurisdiction if there weren't all these filings? I think the judge can rule on jurisdiction either way, and I think the judge should rule and file a jurisdiction so we can move on with our lives. Could they have challenged defamation all the way with jurisdiction and ancillary issues? Yes, they could have moved to dismiss the defamation right along with the motion for jurisdiction. It's another 12. It's another Rule 12 motion. So yeah, you could have moved to for jurisdiction and moved to dismiss for all the causes of action. They moved to for all the other causes of action, just not defamation for some reason, which continues to boggle my mind. Apparently, Minnesota's in the 8th Circuit, so noted. Could Brown have been hired on a limited basis on jurisdictional issue? Could that be the motivation? Sure, that's possible. I mean, who knows what their agreement is between themselves? And lawyers can represent someone for limited purposes, so sure. But if it was really limited, why are we doing all this other stuff? I don't know. In some courts, can PJ be brought up prior to other defenses? Personal jurisdiction has to be brought up first or it's waived. Personal jurisdiction has to be brought up first or it's waived. If you answer, you waive personal jurisdiction. So the very first thing you do has to be personal jurisdiction. You can do other stuff at the same time, but you have to do it first or you lose it. Perhaps other defenses could have been included. Yes, they could have been, and the fact they're not is a bit perplexing. Why do I say the precipices are not relevant to jurisdiction? I thought I filed as part of the motion to dismiss. In some sort of vague sense, I guess they were filed as part of the motion to dismiss, but because that's the only thing on the table. But at the same time, as the judge, when you're looking to the facts, you're looking to what's in the plea, what's in the complaint, and what's in the complaint and its attachments. So all this other stuff is kind of, it can be ignored, I think. So I don't think any of it matters, but that's my personal opinion. What KJ did is the same as everyone else has. Took public docs and mean talked about Toddy, therefore not wrong. That's quite possible. If so, that everyone be covering the case. So be thrown out? If that's true, then yes. Well, it won't be thrown out for that reason because Katie never moved to dismiss the defamation. So it can't be thrown out at this time for that reason. But it could be thrown out at some later time for that reason, assuming that she answers that. But yeah, if all she did was take public documents and say mean words, then there's no case here. And so we can get into that. So maybe she's in the clear. I don't know. Uncivil Law and Nate did not give Brown all her socials. So it doesn't it reason that Salt's declaration may be based on more information than Brown had? It's not clear exactly what Laurie Ann gave Salt's. It's not clear. We know that Laurie Ann has at least 5 different email accounts. It's not clear what exactly what she gave Salt's. So we're not going to assume things that we don't know. She might have, she might not have, but we don't know for sure because we haven't heard from Salt's about this yet. Can you give an example of judge's ire that you've experienced when opposing counsel went too far like this? No, I can't because I've never had anything that even comes close to anything like this. This is a bizarre world. Can I cover Johnny Depp Amber case? Maybe. We'll put it on the list of possibles. Which YouTube lawyer will perform at your wedding ceremony? Will it be live streamed? I don't know, and almost certainly not. No. Can you check to see if the judge has sent out a minute order? I did check while we were talking, and there has not been one as of 5 minutes ago, at least. What's on NAMP's late shade? Is that Jason Max? It is. Or are you doing red light facials? Do you need some Halo vitamins? I think he's fine. Is it too late to just fight this out with the good old rock, paper, scissors? Not the worst idea I've ever heard of. Wouldn't Brown representing LA help KJ, which would be a conflict of interest? He could sway her to things to help. No, not in and of itself. No, there's only a conflict of interest if the parties are adverse in some way. If the parties are on the same team, then that's fine. Lawyers can represent multiple people, even if their interests are slightly different, as long as their interests are not averse to each other. So, yeah, that'd be fine. Yeah. Any idea when the jurisdictional issue will be heard? Not really, but hopefully soon, so we can all move on with our lives. Someone said you're 70% because you're hot. We get it. How about everyone chill? Well, thank you for calling me hot, Mary Hens. That's very nice of you. What is your guys' feeling on who or is what behind the hackers? Don't have any real opinion on that. And my working premise is that it's people who are just doing it for no particular reason who are bored, because this case has drawn that kind of attention. So I think it is unknown third parties who are doing it because they want to help one of the sides, want to hurt one of the sides, or just bored. That's my working premise. Do you think once they get to court, if they do, Salts will offer a settlement, public apology, give me your button, Keemstar? Maybe. I don't know. Possibly. I think what Toddy really wants is some sort of agreement or injunction. She doesn't really want the money. So it's possible that this could be settled out with some sort of permanent gag order. It's not completely unreasonable. If they refile in Minnesota, does KJ become the non-moving party? It depends who's asking for what at any given time. So when you say who's the non-moving party, it depends who filed the motion that you're considering. So Toddy isn't the non-moving party because Tile filed the lawsuit. Toddy's the non-moving party because KJ filed the motion to dismiss. She's a non-moving party with respect to the motion to dismiss. So the non-moving party, it depends who filed what, who filed the motion that we're considering and from what frame of reference. If at some point in this lawsuit, for example, Katie makes a complaint in the legal sense of a lawsuit, if she makes a complaint against Toddy, then Toddy would be the moving party for that motion to dismiss, and Katie would be the non-moving party. So it just depends on what's happening at any given moment. If KJ wins the defamation case, or is it thrown out? Is she likely to have her fees paid by Halo? No. She has no cause of action to get fees. The American rule is everyone pays for their own attorney, and there's no statute in play that would adjust that rule as far as I can tell. Benefit of being in the wonky 8th Circuit, the purely state law, or a mix. They're weird. A panel has to grant habeas, and every other circuit, a single judge could do it. Yeah, I don't know. When you're looking at state law issues, the question is what state law applies, and that would be true anywhere. So even if this is in Washington court, it could be Minnesota state law that applies. That's possible. And even if it's in Minnesota, it could be Washington state law that applies. That's possible. So what law applies is going to be a whole thing. So once you determine that, then you would apply that state laws to its substance. Then the only issues would become like precedent. But if it's a state substantive issue, the relevant precedent is the state Supreme Court. So then it doesn't really matter either way. So if it's tried in the 9th Circuit, 1st Circuit, 8th Circuit, 7th Circuit, wherever, if it's a state law issue, the state Supreme Court governs what's true. So then what you do is you go to the Washington Supreme Court and see if they have something, and so then you do that. So it doesn't really matter. The only reason it would matter is for procedural issues, since this is state law based. And I doubt that there's a substantial enough procedural difference to make a difference here. So yeah, the fact that this is being tried in Washington or would be tried in Washington doesn't necessarily mean that Washington state law would apply. I mean, that would be your default assumption, but you could have a fight over that too. What's the point of Brown arguing both sides? Is some side tactic? He's not arguing both sides. He's trying to slice it very thin. He's trying to slice it very thin. He's trying to argue simultaneously that he was not in fact representing Lorianne, that Lorianne should not have believed that he was representing her, that Salt should have believed that Lorianne was being represented by Brown, and therefore an ethics violation. So he's trying to argue this from multiple different frames of reference. So there's a consistent argument in all that when you're considering it from various frames of reference. You might have answered this, but should KJ win, could the judge awards fees? Only if the only way the judge could award fees is if the case was frivolous, and it's not frivolous. Even if it ultimately loses, it's not frivolous. Frivolous is a much higher standard. Toddy has a reasonable argument. It's not frivolous, so there's no damages to come from Toddy to Katie that I can see. If a lawsuit has multiple documents, but Katie only reported on, say, a third of them, made someone look bad, but doesn't cover the resolution of the case, could that be problematic? Well, I mean, anything could be problematic in the abstract, but I don't think that because you cover one aspect of a case, you're necessarily duty-bound to cover every aspect of the case. Not to put too fine a point on it, but if some reason I decide to stop covering this case, for whatever reason, I don't think that that's a bad thing for me to do. And I don't think it becomes problematic. I just report on the stuff that I report on, honestly and fairly. So could it be problematic? Maybe. But then the answer to every legal question is maybe. So, if Katie were to countersue Toddy, how's that work? Well, it depends what Katie has causes of action for. So does Katie have any cause of action against Toddy? I don't know. What did Toddy do to Katie, if anything? I don't know. I mean, the most likely would be for defamation somehow, but it's not obvious. So I don't know if Katie has any counterclaims. I'm just saying if she did, then here's how that would work. So I don't see any obvious counterclaims, but defamation would be the most likely, and I don't even really see that right now. Thoughts on the sanction against Salts? She was my client versus the motion to continue. She wasn't my client. Yeah, again, you're having to slice this really thin. Brown isn't saying two different things. He's consistent in his position. Brown is saying simultaneously, she wasn't my client. Lorianne shouldn't have believed that she was my client, and Salts should have believed that she was my client. Those are consistent positions. Those are completely consistent positions, if confusing. But yeah, you can have that position simultaneously. I didn't believe it. They shouldn't have believed it, but you should believe it, because different people have different frames of reference. So it's totally possible that I shouldn't believe something and you should believe something depending on different frames of reference. So there's not inconsistent positions necessarily. So I do not agree that these are inconsistent positions. It's just trying to argue it from multiple different frames. Does whether or not Brown can cross-examine Lorianne become moot if the court decides who don't have jurisdiction? Probably. I mean, we'd have to refile and have that argument again somewhere separately, but, quite possibly. Just wanted to say hello from the UK. Hello. Can anyone in this case request that KJ have a psych eval done? Not really. No. And I don't think that she would fall into the guidelines personally, although I'm not a psychiatrist. But from what little I know, I don't think she falls into guidelines for, being incompetent or something like that, given what I know. Brown filed stuff that couldn't really be filed because the rules doesn't exist. That's true. That was a nice touch. Can one set of those documents be recognized? No, the filing doesn't exist. It's been strucken from the record. It does not exist. Is it too late to stop the lawsuit now or end it? No, it's not. It's not. Toddy has the freedom to drop this thing at any time. Either Toddy or Katie has the freedom to offer a settlement at any time. No, it is not too late to end this lawsuit. This could disappear today if the parties come to some resolution. No. In fact, that can happen anytime right up until the jury returns a verdict. If there's a jury, which I don't know there will be. Do lawyers have to declare if they're working pro bono? No. They don't have to declare it openly. But why would you do this pro bono? There's no obvious reason. If money runs out and Katie finishes the suit pro se, do you think she could be successful in representing herself? No. I don't think she could be successful in representing herself. No. I don't think she'd be able to make the right arguments. Wouldn't the court want to hear from Lorianne, though, on representation? No. What Lorianne believes or doesn't believe is kind of not important. The judge, if the judge cares, the judge has enough information to make that decision without hearing from Lorianne. So, although the judge could hear from her, although I don't think the judge will, because I don't think any of this matters. So I think the judge is kind of putting their fingers in there and ignoring it, or kind of hope that's true. Supposing Brown was thrown off the case as a result of conflicts of interest, do you feel KJ could recover a portion of the fees based on malpractice? Malpractice is a really hard trigger. You essentially have to argue that no reasonable attorney would have taken those actions. That's hard. So, I mean, I guess anything's possible, but I wouldn't bank on it. That's for sure. So hopefully I answered all the questions. So yeah. So should we talk more about how I'm not sexist or how different people perceive things? Or are we done here? Katie's pride would never allow her to drop the lawsuit. Maybe. Could KJ sue Toddy because Toddy sued her? No, not in and of itself. No, you need more than that. Yeah, people need to remember the judge doesn't watch YouTube videos, and even though it seems like a big deal to some people, it's not. No, this is nowhere near a big deal in any sort of objective view of reality. I mean, some of you guys can be invested in this case, and that's totally okay. But in the grand scheme, this doesn't even rate a mention, except for its bizarreness. But the actual issues at case are humdrum, routine. You know, as far as the actual case is concerned, there's nothing interesting here. This is just a run-of-the-mill defamation case, or it should be at least. Yeah, literally no one knows who KJ and Toddy is in the real world. Yeah, no one knows who these people are. Right. That's, yeah. Kurt isn't sexist, he's sexiest. I like that very much. That's very cute. Thank you. So many people are like, the judge is probably assisted at seeing all this. Judge isn't watching any of this and barely reading the documents. Yeah, quite possibly. The judge is definitely not watching any of this. First, this for damn sure. The judge may be irritated about the stuff being filed, or they may not care. It depends on the judge. Any thought on SEC versus Ripple? That's the one dealing with appointments of presidential appointments, right? Did that recently come down from the Supreme Court? I'm not sure if I've covered it. Hold on. Or was that last year? Oh, it's cryptocurrency. Oh, it's a different case completely. Before the SEC. Okay. Let me take a look at this real fast. Maybe I'll have to get into that. That sounds kind of interesting. Whether it's a currency or a security. Okay, that could be interesting. Maybe I'll have to get into that. No thoughts right now. There'll be no precedent in the stupid case. There could be precedent coming out of the jurisdiction, which I am concerned about. So if the judge rules that there is jurisdiction here, there are ways that the judge can do that that would create precedent in ways that would be kind of scary. So there is quite possibly some precedent that will come out of this case, but we'll see. If the YouTube videos were entered in evidence, should the judge not view all the evidence? Not at this point, no. They'll take it on the complaint. That'll be more than fine. They're not going to watch the videos yet at this point. Yeah, the question that we're talking about, personal jurisdiction, should be boring minutia. As should defamation, for that matter. I mean, it's all boring minutia, but this thing has become annoying. If Brown's sanctions thing is stricken from the record, does it matter that he's talking on both sides of the mouth? Two bites of the same apple. Is that clever or no? I've tried to make somewhat clear, and apparently I'm not making it clear, but I do not think Brown is talking out of two sides of his mouth. I don't think he's saying two different things. I don't see the problem. Brown is trying to say he didn't in fact represent Lorianne. Lorianne shouldn't have believed that she was being represented, but Saltz should have believed Lorianne was being represented. Those are different things. We're talking about three different people in this equation. I didn't represent her. That's a statement from Brown's point of view. Lorianne shouldn't have believed it. That's a statement from Lorianne's point of view. Saltz should have believed it. That's a statement from Saltz's point of view. So those statements are completely consistent with each other. There's not talking about both sides of your mouth. He's trying to have his cake and eat it too. And he's doing it in a very clever and creative way, which I'm not sure that you have to buy any of this. Now that's a whole separate problem. You don't have to buy it. So I'm not saying you have to believe it, but the argument is different. That Saltz should have believed it. And so Saltz did a bad thing because he should have believed it, even though it wasn't true. So he's not talking on both sides of his mouth. I don't see it that way. And I'll continue trying to explain it if that's not clear. But yeah. Bitcoin passed $1 trillion market cap. That's insane. Should I hold on to Kirkcoin or sell it now? Yeah. There could be precedent set here. Small world of online commentary on YouTube as well as jurisdiction digital world. I don't know how small it will be, but yeah, it could influence online commentary pretty substantially. Do I have any idea when the judge will rule on jurisdiction? No, I don't. I don't have any secret inlay. Could 18242 be used against license due to COVID marking renewal impossible by certain protected items in Google It's in timely fashion? A right deferred and all? No. No, but nice try. No. Why does Brown think Saltz should have believed it? And if it's not true, does it matter what Saltz believed? Well, I don't know as to the second part. Probably not, but Brown thinks it does. Why does Brown think Saltz should believe it? Because Saltz believes that Lorianne told Saltz. No, Brown believes that Lorianne told Saltz that she was represented by Brown. That's what Brown believes. Brown believes that Lorianne told Saltz that Lorianne was represented by Brown. So that should cause Saltz to believe that she was represented by Brown, even though it's not true. Yeah. Am I Gen X? No, technically I'm a millennial. Curious only because we seem to be in the same age range when we aren't easily offended and roll our eyes that look for both reasons, annoying as F. Yeah, technically I'm a millennial, being born in 1981. But of course, it depends where you draw your lines. But yeah, usually because you go in 20-year increments. So being born on 81, I'd be technically a millennial. I'm the oldest millennial. So, you know. I understand your position about stances and agree. That said, credibility seems strange, as I can see his own language being used against him. That's fine. Yeah, you don't have to believe it. You don't have to believe it. But at least understand it. At least understand what you're not believing in. That'd be great. It is pretty convoluted, yes. What if Saltz asked Lorianne and determined she wasn't being represented? Did he still do something wrong? No, probably not. So Brown, I don't think Saltz did anything wrong. Because I also think Brown has a tendency to catastrophize and take the worst possible interpretation of things. So I don't think Saltz did anything wrong, but I don't believe it in the end of the day, but at least I understand it. So it's like, yeah, I understand the logic of it. I don't believe it's true that Saltz did something wrong. So, you know, I'm an elder millennial, something like that. UT, should Saltz have hung up as soon as LA said I could be wrecked by somebody? Not necessarily. He might have had the ability to inquire a little bit more beyond that. to understand exactly what the nature of that is. We're called elder millennials. Okay, well, I'm an elder millennial, I guess. So people born from 2001 on would be a different generation. In fact, we're starting a new generation now. So that's interesting. We're starting the second generation after me. So if we're on 20-year increments, then people born 2001 will be a new generation. And then there are people born 2021 who are yet a different generation. So now I have two generations behind me if I didn't feel already old enough. So what this would take for Salt to show a conversation with LA when she tells him she's not represented by Brown. Something along those lines, yes. If I were a judge, what might call beyond jurisdiction? I don't know enough to know the answer to that question. I'd have to go read the law more intensely to see what exactly the law is in this domain. I've read it peripherally, but I have not read it intensely enough to know for sure. That being said, all things being equal, I think that KJ, well, I'd like KJ to win because I think the alternative raises some really bad possibilities. So I think from a purely legal standpoint, and again, I think it's really important. It's very, very, very important when you're doing this to not factor in the people involved, which I know can be really hard because some people really want KJ to lose. And I totally understand that. I get it. I totally understand it. But when you're looking at law, you have to remember that you don't know who the parties are going to be. And there will be someone someday who's on the other side of this issue that you like. You know, so you can't have a different rule for someone you like and someone you don't like. The rule has to be the same. So my challenge here is when you're creating the rule is you have to remember that there will come a day, probably sooner than you expect, when someone you like will be on the wrong side of this for some reason. And then you wouldn't want the same answer, and you have to have the same answer both ways. So I'm trying to answer this question I'm trying to answer this question without respect to the parties, because I'm trying to answer bigger questions than that. I'm not trying to answer it for this case. I'm trying to answer it for all cases. Yeah, that's what I'm trying to do. I'm not trying to answer personal jurisdiction for this case. I'm trying to answer it for all cases. Forever. So there's that. So my biases are for KJ to win because I think that's the better law going forward for all cases. That takes more than what KJ did. You can disagree with that. You can absolutely disagree with that. But just remember that whatever rule you come up with is going to bite someone in the ass someday. And you don't get to complain about it. So, you know, think ahead. All right, I'm going to sign off for now. This has been fun, but I got to get other things to do. If you're enjoying this content, as always, please remember to like the channel. Please remember to subscribe. If you're not already a member, hit the join button. For 99 cents, you too can become a member. Until later, my friends, cheers and goodbye.